Immigration news and update. Today we're talking about the latest Senate immigration proposal and we will get into the detail. But before we move forward, don't forget to follow this page, obviously, so you won't miss any immigration news and update and any changes that may be actually applicable to you. Now, the Senate came back with a proposal given that we are in an election year, then obviously immigration is front and center. And there have been some back and forth about the aid to Ukraine. And the Republican side of the aisle has actually conditioned the aid to Ukraine to actually controlling and shutting down the border, right? Now, it went from the House, now it went to the Senate, and they came back with a proposal, which is actually pretty detailed. We'll be talking about that, obviously. It can change between now and then because there may be some negotiation, and I'm pretty sure that will be the case, but let's see what are we talking about. And then keep in mind that also this is one of the most sweeping immigration reform, the proposal that we have now. First and foremost, under this proposal, there will be an authority that will be given to the president, to the executive, and this power is actually to shut down the border. Because don't forget that the idea for this proposal is actually to see how to control the flow of people coming through the southern border. Now, under the power given to the executive, that could be activated on discretionary basis. What does that mean? It means that will be basically based on what are the conditions on the ground and after the daily average border crossing top 4,000 over 7 days, meaning 4,000, if we have 4,000 people crossing the border over 7 days, then under this proposal, the executive, the president have the discretionary order, this authority order actually to shut down the border until the processing of these applications have been completed, and then we will be actually back to zero. Now, also, they will be required, not only they have the authority, but the second party, even if they don't want to enforce this authority, to use this authority under this new proposal, they will have to do it, meaning they will be required. This is a requirement, okay? On one hand, you have the authority, but on the other hand, you also have an obligation, you have a requirement to actually exercise this authority, because otherwise the law will be toothless, right? The goal for this law is actually to control the flux of people entering the United States. Thus, we need actually to make sure, according to this law, that this proposal and this authority will be exercised. Now, let's get into even more detail. If now the average border crossing reach 5,000 people over 7 days, then obviously that will be required, meaning the president will be required to shut down the border. Meaning if you have 5,000 people every day over 7 days, the border has to be shut. That's the law. Or if you have 8,500 people trying to enter the United States, then obviously the authority has to be triggered. The president has no choice than to shut the border. Now, meaning basically the president indicated that yes, that's how he's actually designated this power that was given to him, that is given to him under this proposal, the authority to shut down the border, okay? Meaning that will allow him to effectively pause the flux of people coming into the country. That's basically what it is. Now, if someone tries to enter the country illegally, meaning you do not go through actually border processing, meaning meet with a custom border patrol officer, then that will be considered as you enter the country illegally. You will not be allowed to seek asylum. You will only be allowed to actually apply for humanitarian refuge, which is under the Convention Against Torture. That's the law under the United Nations. Because you have to remember that when you apply for protection because you're fleeing persecution, you have the choice under international law, and the United States is a signatory of this law. You can apply for either asylum or withholding of removal or convention against torture. Now, those three, when you file an application, you will see at the top of the application that is actually listed like that. But each of them have legal requirements that are completely different. And I can tell you that to be eligible for Convention Against Torture protection is actually a higher legal standard. It is much, much difficult to obtain. Meaning basically, you enter illegally, you will not have the right to apply for asylum, but you will have the right actually to apply for humanitarian refuge, which is the Convention Against Torture. The difference also, when you apply for asylum, keep in mind that if your asylum claim is granted, then you will have actually the right to obtain your permanent residency based on that, right? But that is not the case when it's actually withholding of removal or Convention Against Torture. Now, if you enter the United States repeatedly, then you will be banned under this authority that is given to the executive, the president, to be banned for 1 year. But now, what about children? Children that come through the border unaccompanied children, meaning they have no adult with them, they do not actually fall under this emergency measure. Meaning everything that I've said, these children will be allowed actually to seek protection in the United States under asylum. They will be able to actually apply for asylum. Meaning they will not be also subject to this particular cap, right? Meaning all the cap that I mentioned is actually applicable to adults, meaning that is not applicable to unaccompanied children. But if the children are coming with their parents or with other adults, obviously they will fall under this particular restriction, under this authority that has been granted to the executive. Now, like every law, when we're talking about an emergency power, it has a sunset date, meaning that it had an expiration date. According to the proposal, this authority will sunset in 3 years, meaning in 3 years it will be sunset, and it cannot be also used for more than 270 days during the first year. 1 year is 365 days. 270 days, that will be the maximum. And also, if the average number of daily border crossing fall by 75%, then the emergency authority will not be applicable. Because you have to remember, according to this proposal, these are measures, an emergency measure. But if the number actually falls, then the emergency measure is not needed, correct? That's the reason why, according to the proposal, then if it falls under 75%, the daily border crossing, then the emergency border actually measure will not be applicable. Now, actually, that once now the emergency measure is invoked, right? Meaning that we see that there are a daily border crossing that have reached a certain threshold. There's like 5,000 daily crossing per day over 7 days. Then obviously it triggers actually a certain number of steps. And in this case, then the bill will mandate that the government at the border will be able to process at least 1,400 asylum seekers at port of entry. 1,400. But where it's actually quite telling, because the idea is to shut down the border, aka they want to discourage people from coming into the United States, correct? But now it will create a new asylum case review. Because currently when you enter the United States and you've been, obviously processed and you go to a credible fear interview, the asylum officer is actually convinced that you do have a valid claim, then you will be released and you will be given a court date when you can actually defend yourself and present your claim for asylum before an immigration judge. Now, under this proposal, it will be different, right? Because they say that they want to make sure that you will be released under what is called alternative to detention, meaning that you may have an ankle monitoring device, and obviously while the case actually review. But the big difference, the case will not be reviewed by immigration court anymore. It will be reviewed by the asylum officer from USCIS. So this is a great departure from what we have now, because what we have now is a backlog of about 3 million cases in immigration court, meaning this is the situation on the ground. Meaning that will be the difference. The idea, again, is to actually process the asylum application as fast as we can, and it will be done on the ground by the asylum officer. The processing time, as a result, will not take years anymore, but it will take months, meaning that if the case has been granted, then you will have your asylum claim granted pretty quickly. However, if it's not the case, then you will see that you will face removal, obviously in a speedy manner. That actually goes without saying. Okay, meaning that's also something that's actually you need to understand. Okay, meaning as far as the credible fear screening, because that's the first step when you present yourself at the border, then they will be actually raised as well, to weed out asylum claim that actually not valid. If you're not eligible, then you will have that as well. Now, obviously, as far as a migrant, it will be harder, because that's what analysts have said, that it's going to make it harder for people to qualify for asylum. And I think obviously then you have to understand that all of this also, in fact, also in light of the fact that it's an election period, it's an election year, there've been an influx actually of applicants arriving in several city centers, and obviously that has been a strain on the shelter system, meaning that this part of the proposed law has actually been welcomed by the mayor in all of these big cities, meaning that's basically to make sure that people who come into the United States will have a valid claim, and obviously, and then their case will be processed pretty quickly. Okay. And also, one thing that will also has been a change is that the bill will not restrict the humanitarian parole authority, of course. Then obviously they restrict the release of the migrant at the land border. Meaning what also that's going to be, part of also the proposed law will be like, if you pass the initial screening, you will be eligible for a working permit immediately. I think this is a welcome measure, because now under the current system, when you come to the United States and you actually present a claim for asylum, you will have to wait 150 days from the moment your asylum application has been received by USCIS in order for you to be eligible for a working permit. Under this proposed law, it will be completely different. You will have the right to work immediately. And I'm sure that it's pretty much tied to the fact that the strain on social services resource, on shelter resource in all of these big city centers, the goal is to make the claimant, the people seeking asylum, to be able to actually be financially independent, to be able to take care of themselves without having to rely actually on social resource that may be available but actually are being stretched thin. Okay. Now, also on the other hand, the number of visas as far as legal immigration will be increased. 250,000 immigrant visa will be allocated over the next 5 years, meaning here we're talking about 50,000 visa per year. And this is applicable whether you actually going through family-based immigration or either through a U.S. employer immigration, meaning both of those, that will be a welcome news for those categories that actually are facing long processing time due to the cap on each category, meaning that we're talking about 50,000 visa that will be applicable and will be used all across the board. And finally, as far as the Afghan that actually have arrived in the United States, after the fall, of Kabul in 2021, will be offered permanent residency and that would be a welcome news, because for the moment, they only have to, obviously they will only be eligible for the right to work. But now it will go from the right to work to actually permanent residency. And also, again, good news. The children of H-1B visa holder who are at risk of losing their status because they are derivative of their parents will have work permit and will be protected against deportation. This is a great news for those of you who are in that situation. And finally, one of my favorite, children under the age of 13, unaccompanied children under the age of 13 will actually be required, the government will be required to offer them legal representation. Meaning, if you are a child, if you are under the age of 13, if you came by yourself, you are unaccompanied, then under this new proposal, then the government will be required to actually provide you with a lawyer in order for you to be represented in court. But that's basically what you need to know about this new proposal. Let me know in the comment what you think. I think it could be like everything else. There are some parts that are extremely stringent, but we understand under the current climate. But there are other parts that I found quite interesting, specifically the representation for minor. For me, I believe that it could even extend to children all the way to the age of 18, because it is very difficult for a child, even an adult, to represent themselves in immigration court. The process can be quite overwhelming, and also it is quite complex. But let me know. Don't forget, guys, follow this page for more information and news. And until then, I see you. My name is Annick Koloko, and I am an immigration attorney. Don't forget to follow this page. Bye.